Good day everyone, especially to you ma'am, Ma'am Mercy Ratonil. I am Rapi Adorimus from Salay, Misamis Oriental. For this video, I will report the Probation Law of the Philippines, the Chapter 3. So, the Probation Law of the Philippines, Presidential Decree number 968 as amended by RE 10707. Next, so A, Philippine Probation Law or the PD 968 was established on July 24, 1976. So on July 24, 1976, Presidential Decree number 968 was promulgated. This law applies to adult convicts and first-time minor drug offenders by the virtue of RA 9165, particularly Section 70. The law, which is more popularly known as the Comprehensive Dangerous Drugs Act of 2002, a child in conflict with the law, or the CICL, under the Section 42 of RA 9344, or the Juvenile Justice and Welfare Act of 2006. So next. So, however, PD 968 was subjected to amendment of other statutes. These amendatory laws are as follows: the number 1, the Presidential Decree number 1257, effective upon issuance. So PD 91257 is effective upon issuance on December 1, 1977, amending Section 7, Paragraph 2, Paragraph 1 to 15 and 333 of PD 968. So number 2, Batas Pambansang BLG number 76, effective upon approval by the President on June 13, 1980, amending Section 9 of PD 968. So next, number 3, Presidential Decree number 93 promulgated on October 5, 1985 and took effect on January 15, 1986, after 15 days from the date of its publication in the official Gazette on December 30, 1985. This law amended Section 4 and 9 of PD 968. So for Republic Act 107, an act amending Presidential Decree number 968 as amended, this act, which is a consolidation of Senate Bill number 2280 and House Bill number 4147, was passed by the Senate House Representatives on September 15, 2015 and September 14, 2015 respectively. It is approved on November 26, 2015 by President Benigno S. Aquino III. Number 5, Republic Act 9344, or the Juvenile Justice and Welfare Act of 2006, amended Section 4 of PD 968 to read as follows. Next. Other laws prescribing disqualifications for probation. So, other laws. So, here the number 6, the Omnibus Election Code of the Philippines, or the Batas Pambansa BLG 881, the disqualification for probation, even the penalty of imprisonment is within the act is within the coverage of PD 968. So, Section 26 for penalties. Any person found guilty of any election offense under this code shall be punished with imprisonment of not less than 1 year but not more than 6 years and shall not be subjected to probation. So, number 7, Wage Rationalization Act or the Republic Act number 6727. The Republic Act number 6727 is under the Section 12. Any person, corporation, trust, firm, partnership, association, or entity which refuses or fails to pay any of prescribed or increased adjustment not less than 25,000 pesos or 25 more thousand 100,000 pesos or imprisonment of not less than 2 years or 1 more than 4 years or both such fine and imprisonment at the discretion of the court, provided that any person convicted under this act shall be entitled to the benefits provided under the provision of law. So, number 8, Comprehensive Dangerous Drugs Act of 2002 or the Republic Act 9165. So, under the Section 4 Republic Act 9165, non-applicability of the provision law of the drug traffickers and pushers. Any person convicted for drug trafficking and pushing under this act, regardless of the penalty imposed by the court, cannot avail of the privilege granted by the provision law or Presidential Decree 968 as amended. Next. So however, sections 57 and 70 of RA 9165 requires the applicability of the probation law. So number 9, the probation and community service under the voluntary submission program. Section 57, probation and community service under the voluntary submission program. A drug dependent who is discharged as rehabilitated by the DOH accredited center through the voluntary submission program but does not qualify for exemption from criminal liability under Section 55 of this Act may be charged under the provision of this Act but shall be placed on probation and undergo a community service in lieu of imprisonment or fine in the discretion of the court without prejudice to the outcome of any pending case filed in a court. Such drug dependent shall undergo community service as part of this is her aftercare and follow-up program, which may be done in coordination with non-governmental civic organizations accredited by the DSWD with the recommendation of the board. So number 10, probation or community service for a first-time minor offender in lieu of imprisonment. So number 10, Section 70, probation or community service for a first-timer minor offender in lieu of imprisonment. Upon promulgation of the sentence, the court may, in its discretion, place the accused under probation even if the sentence provided this act is higher than that provided under existing law and probation or imposed community service in lieu and imprisonment. So that's all. So amplified applicability of the probation law. Number 11, Optical Media Act of 2003 or the RE 9239 repealed PD 1987 or an act creating the Videogram Regulatory Board. So, there is an express provision under PD 1987 that the probation law shall not apply in cases of its violations. However, under 92239, there is no longer a provision that clearly excludes the application of the probation law in case of its violations. Hence, since the latter law is more favorable to the convict and applying the purpose and intention of the probation law, persons who are convicted for violating this law shall be allowed to be placed on probation. Now next. So, B, the purpose of the Philippine probation law. So, in this section, we discuss about the purpose of the Philippine probation law. So, number 1, promote the correction. So, number 1, promote the correction and rehabilitation by providing the offender with individualized treatment. So, I promote. Number 2, provide an opportunity for the reformation of an offender which might be less probable if he were served a prison sentence. So, and number 3, prevent the commission of offenses of Section 2 PD 968. So, the other purposes is to establish a more enlightened and humane correctional systems that will promote the reformation of offenders and thereby reduce the incidence of recidivism. And number 2, to avoid confinement of all offenders in prisons and other institutions for rehabilitation that surely constitute an onerous drain of the financial resources of the government. So next. So notes. As an individualized and community-based treatment, probation created a relationship between the probationer and the probation officer, the latter exercising supervision over the former. Probation supervision implies a systematic guidance and assistance of the probation officer for personalized treatment for the probationer. And the other is as an opportunity for reformation. Section 2 expresses the concept of probation as an opportunity for reformation. And to prevent the commission of offense, probation is an alternative to incarceration. So, C, advantages of probation. So, let's tackle about the advantages of probation. So, number 1, it prevents crime by giving freedom and rehabilitation to only those convicts who are not likely to recommit of penal laws. So, it is preventing the crime by giving freedom of the person. So, number 2, it protects the society by placing the probationer under supervision of probation officer. 3, it conforms the concept of restorative justice. It gives another chance in life and provides opportunity to be rehabilitated to the penitent convict. 5, it prevents the first convict to become hardened criminal. So 6, more economical or least costly on the part of the government. 7, provide solution of overcrowded jail and prison facilities. 8, it restores successful probationers his civil rights. And 9, it makes the probationer a taxpayer instead of taxator. So D, statutory attributes of Philippine probation system. The probation system established in the Philippines has at least 3 important characteristics that make it different from other probation systems of other jurisdictions. So number 1, it is a once of a lifetime offer. So meaning that a convict person can only avail the privilege of probation once in his lifetime. Yet if he is convicted again, such person can no longer avail himself of another probation. However, in Western countries, a person can avail of probation as many times as he is convicted of violating penal laws. So, once in a lifetime lang ang attributes sa probation. So, number 2, selective application. Selective application probation is made available only those who convicted of certain crimes. Crimes against national security like treason and espionage are excluded. Those who are sentenced to prison terms of more than 6 years are also excluded from the probation privilege. So 3, persons under the probation retain their civil rights like the right to vote or practice one's profession or exercise parental or marital authority. In most Western countries, in order that a person who had undergone probation may be restored his civil rights, he must be initiate separate court court proceedings. It is relevant to notice that the Presidential Decree number 968 is a legal framework which will serve as a basis for the implementation of the provision in the country. So, number 4, the suspension of the execution of sentence in conditional. So, the suspension of the execution of sentence is conditional. Violations of any of the conditions may cause revocation of the privilege. 5, conditions of probation to be imposed by the court to protect public safety and of foster the rehabilitation and reformation of the probationer. So 6, jurisdiction of the court is continuing in character. 7, post-sentence investigation report is mandatory. So post-sentence investigation report is mandatory, which will serve as informational guide for the court's decision in granting or denying the same. Number 8, supervision, guidance, and assistance by the probation officer over the probationer. So that's all, ma'am. And thank you. Mabuhay.